to welcome all of our students, number one, and some of our special guests, some local attorneys, law clerks, all different type of people, along with the Supreme Court. We definitely want to welcome, and it is a great privilege for us to be hosting them here today for this hearing. Students, I want to first off commend you how awesome you've been walking into the room. It is 9:50, we are on time, you're all sitting. It's exactly what we expected, and I do appreciate your cooperation with all of that. I'm pleased to introduce our MC today, Assistant Chief Judge Rachel Sullivan. Assistant Judge Sullivan is your Assistant Chief Judge. She serves the 6th Judicial District that includes St. Louis County. Judge Sullivan is a graduate of Boston University and received her law degree from Mitchell-Hamlin School of Law. Prior to appointment to the District Court bench in 2018, she served as an attorney in private practice and as a law clerk for the Minnesota Court of Appeals. In addition to her role as Assistant Chief Judge, she is the current presiding judge of the Northern St. Louis County Mental Health Court and a member of the Iron Range Equal Justice Committee. Please help me welcome Assistant Chief Judge Sullivan.
Good morning, everyone. Welcome. So I want to say welcome to our host school today at Rock Ridge High School, our special guests, as well as faculty, dignitaries, and court staff who are joining us this morning. And a special welcome to those who are joining us on our live broadcast. I'm not sure where they are, but anyway, welcome to them. All right, so I'm going to talk to you a little bit about the court system today. I think a lot of you have already got some education about this and have had some lawyers come meet with you and talk with you about how our court system is structured in the state of Minnesota. But we're going to talk a little bit first about how old. Does anybody know how old the court system is in Minnesota? 150 years old. The court system is older than the state of Minnesota itself. We're divided into 3 levels. We have the district court level. I'm a district court judge, and I'm chambered in Hibbing, Minnesota. That's where most cases begin. We handle everything from traffic tickets to murder trials. We have 10 districts in the state of Minnesota and 296 district court judges. Then the next level of courts is the Minnesota Court of Appeals. Their main court is in St. Paul, and they have 19 judges there who hear appeals from the district courts. And then the top court of the highest court in our state is the Minnesota Supreme Court, and they have 7 judges and 7 seats, obviously. So last year, Minnesota handled approximately 1 million court filings. The Supreme Court, again, which is considered the court of last resort in the state of Minnesota, decides about 150 cases per year. So how does a case get to the Supreme Court? Supreme Court hears appeals from the decisions from the Court of Appeals, as I just mentioned, the Tax Court, Workers' Compensation Court of Appeals, where this case originates. The Supreme Court automatically hears appeals out of the the Supreme Court automatically hears appeals from first-degree murder trials. So if there's a first-degree murder trial at the district court, it automatically goes up to the Supreme Court. It also hears legislative election contest disputes. So the case you're going to hear today is a real case. It's State of Minnesota's the respondent versus Ivan Contreras-Sanchez, the appellant. Ivan Contreras-Sanchez was convicted of second-degree intentional murder after being identified as a suspect through location history data provided by geofence warrants served on Google. Mr. Contreras-Sanchez moved to suppress all evidence obtained from the geofence warrant and all fruit of the poisonous tree, including his identification. The district court, that's the first court, denied that motion, and Mr. Contreras-Sanchez was eventually convicted following a jury trial in Hennepin County. He appealed to the Minnesota Court of Appeals, and the Minnesota Court of Appeals confirmed his conviction. The Supreme Court is allowing review, and that's what you're going to hear today. So there are several issues in front of the court today. The first is whether geofence warrants are categorically prohibited as general warrants under the United States Constitution or the Minnesota Constitution. 2, if geofence warrants are not prohibited, whether this warrant established probable cause to search the data of users who were merely present within the geofence boundary. And 3, whether the geofence warrant was insufficiently particular and overbroad, where the warrant allowed the seizure of all users' data over 7 days in a location that encompassed a public road, and where the warrant allegedly gave police unchecked discretion to determine which devices to target. So that's a lot, but there are 3 issues in front, and I encourage you to really pay attention to that. Today, you'll notice that there are only 6 justices on the bench. That's because Justice Theodora Gaiatis has recused from this matter. A recusal is when a judge withdraws from a case because of a potential conflict or because of the appearance of a conflict. Justice Gaiatis will participate in the question and answer after the case. So the last thing I want to talk to you about, and you're already doing a really great job, is the rules of decorum. That's something that governs all courts. And the case you see today, as I said, is a real case. There are very important issues that are going to be decided, and it's critical that the justices and attorneys are not distracted. So we're going to ask that you abide by the same rules you would if you visited any courthouse in the state of Minnesota. Any activity that distracts from the court process is grounds for removal from the center, and keep in mind that the total time for the arguments is about an hour. So we'll give everyone time to stretch after the arguments are completed and before we start the question and answer. So now with that, welcome everyone. It's time to convene court in Rockridge High School Performing Arts Center.
Please be seated. Okay. Good morning to everyone. We have one case on our oral argument calendar this morning, Contreras-Sanchez versus State of Minnesota. The record should reflect that Justice Gaiatis is recused from this matter and will not be participating in the deliberations or the decision of this case. Just a reminder to both counsel, I know we have experienced attorneys with us today, but as a reminder, you'll each have 3 minutes of uninterrupted time to make whatever opening comments or statements that you'd care to make to the court. At the end of those 3 minutes, if you have not stopped yourselves, I will stop you to see if the court has any questions. Ms. Workman, I understand that you have reserved 5 minutes for rebuttal. Is that correct? All right, you may begin whenever you're prepared to do so.
Good morning, Your Honors. May it please the court and counsel. My name is Jennifer Workman. I'm an assistant public defender, and I represent the appellant Ivan Contreras-Sanchez. This case presents novel issues concerning the constitutionality of geofence warrants. With a geofence warrant, police are able to tap into Google's vast troves of location history data to track the movements of anyone within the geofence's boundaries and ultimately to identify a suspect in a crime. This warrant allowed the police to seek all the location data for every user within an almost 19,000 square foot area over a 7-day period without interruption. Cell phone users have a reasonable expectation of privacy in their location data. Law enforcement's intrusion into that private sphere amounted to a search. We are asking this court to find that geofence warrants are prohibited general warrants because they permit sweeping intrusions into private protected data without a check on law enforcement's power. Alternatively, this geofence warrant was constitutionally invalid for several reasons. Cell phones might be ubiquitous in today's society, but that fact on its own does not confer probable cause. The warrant allowed police to search all of the user's data based merely on their location, not because police had probable cause to believe that each user was linked to a crime or that they had a Google-connected device. And the warrant violated the specificity requirement because it was not narrowly tailored as to time, location, or scope. In the digital age that we live in, where our cell phone data contains some of the most sensitive and private information, it is vitally important that we restrict law enforcement's ability to rummage through that data. The federal and state constitutions enshrine individual privacy over the interests of law enforcement. And Mr. Contreras asked this court to reverse his conviction. At this time, I welcome the court's questions.
Counsel, many of us use our phones to deliberately allow people to track us on the phones. Many of the people in this audience allow parents to track them on their phones, just as one example. Why should we say that there is a reasonable expectation of privacy in our location, given the ubiquitousness of people doing that?
Number one, Your Honor, that assumes that you're assuming that we would be sharing it with law enforcement as well, and that is not the case here. We don't know that the people who agreed, if they did agree, because the record is absolutely absent here as to what the opt-in process was. But let's say that they agreed to share their location data. They agreed to share that with Google, not with law enforcement. There is a big difference there when you're saying, yes, you may use my data to track me for your business purposes.
But counsel, if you agree to share it with Google, there's no control over who Google's going to share it with. So where is the expectation of privacy?
I would say the expectation of privacy comes from Carpenter, Your Honor, and that's a precedent binding on this court. Carpenter held that cell site location information, there is a reasonable expectation of privacy there. It is a logical extension to also hold that there is a reasonable expectation of privacy in your cell phone location history as well. The two are very similar technologies. The state's trying to split hairs to try to say that they're different, and they're not.
But isn't the fact that Google users opt into the usage of the data, isn't that a significant difference from the cell site location information?
It may be, but we don't have the record here to know what the opt-in process was. When you look at every...
But do we need to know what the opt-in process was? Isn't the fact that we know that it was an opt-in process of some sort enough?
I think you do need that, because when you look at every other geofence decision that has upheld a geofence, it's because they had a massive record on what the opt-in process was, what the technology was, Your Honor. And we don't have that here. We can't say who did what or why or when. And that is critical information that we're missing that other courts had.
Is the record giving us any information about what Google tells users they need to do to opt out of this location information?
The record has nothing in it about that, Your Honor.
Counsel, the state argues that in Carpenter, it was more of a wide dragnet sort of situation, whereas here, the location data is much more pinpointed, if you will, much more specific. What's your response to that? Because it seems like it does seem to me that Carpenter was looking at a much broader area of information.
Well, 2 points, Your Honor. We should be scared because it is so specific and accurate, and your location can be pinpointed much more precisely than in a CSLI. And 2, even that pinpoint of data is deeply revealing of where you have been, some of the most private information in your life. It shows information that you may not have wanted to share with Google, much less law enforcement. Because of that, We have to extend Carpenter. It is, like I said earlier, a logical extension. This is more precise. It gives more abilities to law enforcement because of its precision.
Counsel, can I, this is maybe an expansion of Justice Hennessy's question, but, and I'm thinking, really big picture here as a policy matter. We, as citizens, we forfeit a lot of our privacy every single day, and we do it knowingly, I think, especially in this day and age, when we give out information about ourselves online, when we shop at the Gap or wherever we shop. Every time you go in and you're shopping, we know that cookies are being applied and we're being followed. And that's why after you get to the end of the day, if you haven't bought anything, you come back online, still interested? A little thing pops up. We know in today's age that we're being tracked. And it seems to me as a society, we've said we're okay with that for the most part because we keep using our phones. We keep doing it. And we do it because it's convenient. And so I'm wondering, just in that big picture, where's the expectation of privacy given the way we use our phones in our everyday lives?
I would respectfully push back on that, Your Honor. It's not just, a cell phone in today's society is not just a convenience, it is essential. You have to have a cell phone. So tying yourself to a cell phone is like tying and agreeing to being tracked would be like saying DUI roadblocks are perfectly fine nowadays. Now, we know that's not true because Asher has held that it's not true. What we're saying then is that we get to sweep up the data of anyone who comes through a geofence boundary just because they have a cell phone.
I'm going to push back on you saying that everybody, it's required or essential that people have a cell phone. I mean, in my hometown, there's a lot of people who do not have a cell phone. So I'm not so sure that that's an accurate statement. That seems to me to be an overstatement. There might be a lot of people who use them, but there are also still people who don't.
Certainly, that is true. But also, Your Honor, I think we can't deny the fact that the vast majority of people in this country now own a cell phone and use it. I could not get here today without using my cell phone for location data.
Counsel, that's kind of my point. I bet you everybody that drove here, certainly from the cities, used Google Maps to get here.
That's true, yes,
And-
or Apple Maps.
We use one or the other to get here. And we all know and understand that that's a convenience. It helped us get where we want to go. It'll help us get home. But haven't we as a society at some level decided to forfeit our privacy in that information?
I think that argument was posited to the Supreme Court in Carpenter, and it was rejected. And the reason it was rejected is because just because you carry a cell phone with you doesn't make it an ankle monitor. And that is the exact language that the Carpenter Court used. It becomes an ankle monitor then. Are we really accepting that law enforcement and Google and whoever else can follow us wherever we go? Or do we still have privacy rights
But
in
you
this
can
country?
turn the location search off, because I know one of my colleagues on the way up here, there was a request that came up, do you want to share your location? And I know that even on my phone, maybe it's because it's a Google Pixel, sorry, Apple, but that I'm constantly asking me that question. And as far as not being able to get up here without that, I'm not sure that that's true either, because there are lots of part of the state, particularly up here, where there isn't really good service when it comes to cell phones. So you could have easily looked at a map and looked at your directions, written them down, and gotten up here without the use of your phone at all.
I agree with that. And, I want to bring that back to what the police could have done in this case. The police acted like the geofence warrant, that they were at a dead end. And the geofence warrant was what cracked this case for them, right? What they could have done instead of using a geofence warrant that was constitutionally invalid is do some old-fashioned police work.
Counsel, I want to talk for a minute about the probable cause issue here. Let's assume for the sake of argument right now that we do find that there's a reasonable expectation of privacy to some degree or another in this data. In this particular case, where what we have in the warrant is sort of a statement that Google collects and stores data from those who use a variety of products, right? Tell me why that is not a fair probability that they would find the information they were looking for with respect to location of the suspects in Google data?
Because that statement relies upon solely a person's location. And as we know from Ibarra, location is not enough to create a nexus for probable cause.
But wasn't Ibarra about a person and the propinquity of a person, not things like data in this case?
Well, you would have to get that data, a person has to carry the cell phone in the geofence boundaries. So I think that we can't split those hairs either.
What if Google had a old-fashioned video camera trained on this same spot for the same period of time? Would there not be probable cause to get a warrant to obtain the video coverage of that spot through that time, given the crime that occurred there?
Our position is that if police had more of a nexus, such as video, such as interview statements, such as cell phone information from the victim's phone, then they may have been able to have a constitutional warrant here.
But how is this different than that? I mean, in a sense, Google is focused on this spot and can see who's coming and going from that spot, just like they had a video camera there. What's the distinction? Why is this sort of data different than just visual video data of that same location?
Well, I'll bring you back to other things that are ubiquitous in our society, such as cars. We don't allow police to just stop cars and search them randomly. We have to have probable cause for that. Other things that are ubiquitous, homes. We don't allow police to go in and search homes without probable cause.
Well, again, would police have probable cause to obtain the video footage if there were a security camera trained at the same location that the geofence described?
If the security camera caught suspects and the video showed them using cell phones or some indication that they had cell phones with them, and there were additional facts that are not present in this case, then it may have been.
But I'm giving you the facts. The fact is just that there's a video camera trained at the culvert where the body was found. Would police have probable cause to get that video footage?
It depends on what the video camera shows. If it shows them what...
Well, they don't know. They just know that there's a camera trained on it. In the same way they don't, that Google is trained on that particular geographic area.
Then I would say no, Your Honor. They don't have enough information at
So
that
there's
point.
a video camera facing where the crime takes place and the police can't view the footage? There's no probable cause?
They, again, need to have a nexus before they even get to
But
that
isn't the
point.
dead body?
The nexus is that they have information tying the person, the cell phone, to the crime.
What about the fact that this data they're alleging is anonymous, so that there is perhaps, if it's anonymous data, why should we care about that?
Well, several points to that. Anonymity is not the cure-all here that the state would claim that it is. No geofence decision has ever held that anonymity is perfectly fine on its own. And as we know from those decisions, it's not anonymous for long. The police get to choose who they target in the anonymity process. So that they could choose the wrong person and target that person for unmasking starting in step 2 to get their movements from an hour before, an hour outside of the geofence boundaries. Then they can target that person again, or that account again, for subscriber information, totally unmasking their identity. At that point, they are not anonymous. Anonymity is a red herring. It does not provide the protection that the state would like you to think it does, because the police have the ultimate power to overrun that anonymity and find out whoever is attached to that data.
Can you go back to Justice Procaccini's question? Because I would like to hear the answer.
Yeah,
So-
and again, in my mind, the nexus is the dead body in the culvert. And
So-
so if there's a video camera trained at that culvert, it seems very problematic to say, no, the police can't look at that footage because they don't know who might be in it. That's the whole purpose of the investigation.
So our nexus case law, starting with Illinois v. Gates, is that the nexus is connecting the person to the crime, so the suspect to the crime. It is, in this case, it would be connecting the suspect to the data that we need, And there is not a nexus here. We don't have anything that's showing that these people were connected to this crime.
But if there's a robbery, so someone holds up a convenience store, don't police all the time get to go and look at the video camera of that?
Absolutely.
So what's the distinct, maybe the distinction is that's not ubiquitous, so it's not the kind of information that we're worried about.
I want to be clear that in a video camera, your identity is not necessarily obvious right away. In location history, it is, because your account information is tied up to it.
Well, but it's only obvious if you get to that stage 3, right? And the police did get a separate warrant on that.
I would say that it is not obvious at stage 3. It starts at stage 2, because they can start looking closer at you at stage 2, targeting those accounts that they think that they want to follow for an hour before, an hour after. And then they further target you in stage 3. And to the point that there is a second warrant here, that warrant depended entirely upon the data that they got in the first warrant. And that warrant, if the first warrant falls, the second warrant falls, and vice versa.
And just to clarify though, but your answer to my question is if there were a video camera trained on the culvert and the police just knew that there was a dead body in that culvert.
Right.
You don't think that would be enough for them to have probable cause to get a warrant?
I want to be clear. I think they can because it's a video camera. It's different. Location history is a different species altogether. Location history will reveal who you are right away. For a video camera, the police have to do additional investigation to find out who that is on the camera.
But it seems to me that actually they're similar in that you could walk right up to the video camera, in which case your identity would be very clear, in the same way that maybe your location history would also make it very clear. But it doesn't seem obvious to me that everybody's identity would be revealed by knowing where they were for 2 hours or 2.5 hours.
So again, I would say that with your cell phone, you carry much more private data with you than what may be shown on a video camera.
Well, that's for sure, but they weren't getting anything other than location data in this case,
and location
right?
data can be very revealing.
Okay, but they weren't getting anything else off the cell phones. They weren't getting pictures and contact lists and all the other things that we store.
That's true, and still this was a constitutionally deficient warrant, because there is no nexus, because it allows way too much exploratory power to law enforcement, because it's not specific enough. It's 7 days over a 19,000 square foot area encompassing a public road. So anyone who drove through that road, their history is taken.
So what if it was 3 days and 900 square feet?
Your Honor, I would point you to the Fuentes case that I've filed as a supplemental authority this week. And that case from the Eastern District of Oklahoma had a 10-minute window for a hit and run that happened on a reservation in Oklahoma. And that was a death investigation. They had video of the car. And still that court held that geofence warrant was a general warrant. The reason being was that the language gave too much discretion to law enforcement to rummage through all the location data for everyone who drove through that area during 10 minutes in a smaller area than what we have here, also encompassing a road.
Counsel, let's assume that we do find that there's an expectation of privacy in this data. Can you tell me what kind of warrant in this case could law enforcement have drawn that you would think was constitutional? Is there one?
First, I would have law enforcement do much more investigation before they sought this warrant. So
let's assume that we find the first step is sufficient. What comes next? How would we make the rest of it constitutional?
I don't know how you find the rest of it constitutional if the first step is
You don't think there's any kind of warrant that would have made this constitutional?
The first step is really the worst step here, to be honest, because it all starts with the first step. So what I would have this warrant do, if it were going to be constitutional, is first have police do much more investigation so that they get these cell phone numbers of the people involved. They are able to target those people, the suspects, from the first step. We're not going to sweep up everyone who happens to be traveling on a public road. We are going to target the people from step one that we want to follow. And because of that, that would require them probably to look into the victim's location history, to the victim's cell phone records, pull the cameras from the homeless encampment, see if you see people coming and going there, if you recognize any of them, compare it against other information that you have, do old-fashioned police work. Go to the houses around there, interview the neighbors.
But counsel, it seems like this was an incremental process, and why wouldn't we want law enforcement to use this incremental process where I think they thought about the things that you're talking about step by step. And the first step, yes, it's narrowing, but it's all anonymous. They don't know anything further than the location information.
Again, that anonymity is such a thin reed for us to rest upon. The anonymity can come and go, and it is up to the police department as to whether they want to unmask you. It gives them too much discretion to decide who they want to target and go after. And we should not be comfortable with giving them discretion in that situation where Carpenter says we have a reasonable expectation of privacy, where we all carry cell phones, and those cell phones have some of the most private information that we do not want shared with other people.
Counsel, it almost sounds like, and this is how the state characterizes that argument, that you would be requiring that law enforcement have a suspect from their good old-fashioned police work, that they have a suspect. They've gotten the cell phone number and identified who that number belongs to, that they have to do that first. But is there case law that says, because I'm not sure that there is, that there has to be a suspect in mind? Because isn't that the whole point? Are we hampering law enforcement, I guess is my question, too significantly by requiring that they have a suspect when part of the reason you do what you do in these instances is so that you can find the suspect?
I agree with that, Your Honor. There is not a case that says that you have to have a suspect in mind before you seek a geofence warrant, and we're not positing that as the rule of law here. What I am suggesting to Your Honor is that there was more to be done before they got probable cause. The probable cause is lacking here because they didn't do a sufficient investigation.
Counsel, you had said that they had to have cell phone numbers and then, using that more detailed information. That seems to me that they would have had to have a suspect in mind.
So they knew that there may have been several people involved here. They had a nickname for my client. They had names for other people. They had more information to go on that they could have used to do more interviews, go pull, like I said, the shot spotter information, the cameras from the homeless encampment. There was more for them to do, but they did not feel like, for whatever reason, they could do those things. And so law enforcement sought this geofence warrant too soon without doing enough of an investigation to get the information to be able to provide that probable cause.
So
Counsel, go ahead.
So counsel, let's change the facts of the hypothetical a little bit. Let's assume we're talking about a rural area, burglary of a farm. Farmer has a trail cam that's on a path, captures a grainy image of a suspect with a cell phone in their hand, nobody else around. Wouldn't, in that particular area, law enforcement be able to get a very narrow geofence warrant, limited in time and location? They know, a timestamp on the trail cam that virtually guarantees that the warrant would only capture the location history data of that particular cell phone or that through the geofence. I mean, wouldn't that be constitutionally appropriate?
I think you're giving me almost the exact facts of the Tominick case from Maryland. And yes, I would agree that that would probably be sufficient. However, bringing us back to Tominick, there is strong language in that case about how geofence warrants have the power to push way far into our privacy rights than they should.
Oh, absolutely. And the advocates and the amici here raised really legitimate points about that. But this was Castle Rock Township, Dakota County. And this is a relatively remote area of a rural section of a county. I mean, this wasn't downtown Minneapolis or Duluth or something like that. I mean, it seems to me that what the law enforcement did here is much more analogous to that Maryland case.
I do respectfully push back on that, Your Honor, because at this point, then, we're creating sort of a urban law versus rural law. We've got to have a law that covers everyone. And the law that is good for the rural areas has to be good for the urban areas. That law is that you have to come with probable cause establishing a nexus between the users and the crime that's found within the geofence warrant boundaries. And that is true whether you are on a farm or if you are in a densely packed city. And
Counsel,
if
can you assume for a moment that we are going to find, just for the purpose of this question, that step one, there was probable cause? What is the problem then if we find that with step two?
Step two allows police too much discretion to determine who they want to target.
So it's a particularity problem?
Right, without judicial oversight. Where is the magistrate in that situation where police can go back and forth with Google about what they want and how to draw their boundaries? Where is the magistrate when police say, you know what, we think it is account number 14. Let's go after account 14 and we'll unmask them. There is no judicial oversight. That is the point of a warrant, and yet that is totally lacking here. And that's where we fail in the particularity, the specificity, overbreadth, and also why it is a general warrant as well.
Is there any amount of, so again, we're assuming we're good on step one, we're just looking at step two. If the warrant had said you can get 15 minutes before and after they were in the geofence, would that survive? Like, are you just saying you can't go beyond the
I would say
geofence,
any time.
or-
I would say any time that you give unbridled discretion to law enforcement to decide what they want to do and who to target without judicial oversight, that is a problem. Whether it is 1 minute or 600 minutes, it
But if
doesn't
it's just-
matter.
I mean, if it's just 1 minute, then they're seeing the direction the person's going when they entered the geofence or after the geofence. Like, doesn't every warrant give some degree of discretion to the law enforcement officer who's enforcing it? Like, it doesn't.
Not to this degree. And this degree is much different than your traditional warrant in that they go back and forth, as we saw here with Google. Google told them, hey, you're 31 days. That's too long. Could you narrow that down? Sure, we'll narrow it down to 7 days. No judge ever signed off on that.
Well, wait, so you're saying a police officer can't conduct a narrower search than what's permitted?
No, what I'm saying is that they were able to talk to Google and change this warrant. And yes, they did narrow it, but what's to say that they wouldn't expand it? Or somebody else would
The parameters of
expand
the
it?
warrant, I would hope. I mean,
But that, again, gives them too much discretion. They have too much discretion to decide. They get to conference with Google in this without a judge saying, hey, you know what, that's not what I signed off on. They sign off at the beginning, and whatever happens afterwards is up to law
Well, it seems
enforcement.
really different to say the police officer's narrowing the scope of what the judge permitted them to do versus going beyond the scope of what the judge permitted.
But it wasn't a judge giving them that discretion, it was Google giving them that discretion. It was that direction, I'm sorry, not discretion.
Well, but if you had an ordinary warrant where they're allowed to search a premises and they decide not to search a room, they're narrowing the scope of the warrant in a sense, but that's permissible,
But that's
right?
almost like saying we allow house-to-house searches, but we didn't search one house to find a gun.
Isn't the real issue that they expanded beyond what the first step was to
That-
go farther? I mean, whether you're going a little farther or you're going farther.
That's it, yes, Your Honor, yes, I would agree with that. I see that my time is up. Thank you, Your Honors.
Thank you, counsel. Mr. Petrus.
Good morning. May it please the court, counsel. I am Assistant Hennepin County Attorney Adam Petrus, and I represent the respondent in this matter, the state of Minnesota. This court should affirm all of the lower courts, and I'd like to make a few points at the outset. First, step 1 and step 2 of the Google 3-step process were not actions subject to Fourth Amendment protection To be clear, a specific person has a Fourth Amendment right to be free from unreasonable searches, but a cell phone or another electronic device as a non-living item does not. Anonymized data about a cell phone's location that does not connect that cell phone with any identifiable person is simply not protected by the plain text of the Fourth Amendment. Anonymous device data may require a tracking warrant under Minnesota statute section 626A.42 subdivision 2, but that does not also make obtaining that information a search, as that term is understood under the Fourth Amendment. And I believe the state advanced this argument on pages 5 to 7 of its district court memo, but even if it didn't, under State v. Grunig and Criminal Rule 29.04 subdivision 6, as the responding party in this appeal, the state can raise a new argument as long as there's sufficient facts in the record to support it. The second point is that the touchstone of the Fourth Amendment is reasonableness, and all Fourth Amendment analysis are incredibly fact-dependent inquiries. In this case, under the deference that all reviewing courts, including this court, must give to magistrates' decisions to issue warrants, the geofence warrant that resulted in information under Steps 1 and Step 2, and the later separate warrant that resulted in identifying information under Step 3 were reasonable under the specific, unique factual circumstances of this particular murder investigation. And that includes where the victim's body was found, how long the victim was missing, and the condition the victim's body was found in, as well as other information that law enforcement had from informants when it applied for that first geofence warrant. And third, geofence warrants at their core are like a surveillance camera trained on a specific, fixed, limited area, and are actually less intrusive than cell tower dumps, for an example, which involve the gathering of many identifiable phone numbers. A geofence, especially the one authorized by the warrant in this case, is not a, quote, all-encompassing record of a known individual's physical movements or an intimate window into a person's life, like the Supreme Court held in Carpenter. They should not be categorically barred, and the Fifth Amendment that concluded otherwise was simply wrong. At this point, I welcome this court's questions.
Counsel, you claim that in Steps 1 and 2 that the data that they're getting from Google, these device IDs, is anonymous data. But is that actually true? Because wouldn't there be many scenarios where it's not really anonymous? For example, if the security footage obtained after Step 2 revealed one car pulling up to the gas station, just one, and one person getting out of that car, couldn't police run the plates of that car, compare the man in the footage to the picture on his driving record, and identify him without ever having had probable cause for that particular person?
They had probable cause for that particular device, and that device is what led them to the Speedway gas station under that different version of the facts compared to what we have here.
But does it make it, do you see what I'm saying about it? Is this really anonymous data? That's what I'm trying to figure out. Do you think it's safe to call this all anonymous data?
I think it is. I think it's very anonymous. I think if you look at Rasmussen hearing exhibits 2 and 3, those are the Excel spreadsheets. They have 7, 10-digit numbers assigned to each of these devices. And I understand at Step 2, they're able to expand the 60 minutes forward and backward to get to that Speedway gas station. But in this particular case, it did not lead to, appellant in terms of him being there, identifiable in that surveillance video.
What if of the 11 people, there were 3 that were there for 10 minutes at different times, right? Mm-hmm. And then they did the expanded to 2 minutes, and they found around that time people pulling into the gas station at all 3 of those times. Building on Justice Hennessy's question, then there's a lot of innocent people that are going to be pulled in to this investigation. And I think one thing we have to remember is that this is not really about the defendant's privacy rights. It's about our privacy rights. So doesn't that, I'm building on what Justice Hennessy just asked, I mean, that is actually getting unanonymizing data on a lot more people. I mean, the facts of this case make this question a little bit trickier. I mean, not trickier legally, but it kind of frames the issue in a way that maybe we miss the bigger picture.
That's an excellent question. I think that, if in those particular facts, because if you look at, I think it's Exhibit 6 in the suppression hearing, you see all 46 of those data points right above the culvert. It's incredibly clear.
But what if there were 3 like that?
Exactly. So then, again, anonymous at Step 1, anonymous at Step 2, and then you have to go back to to the magistrate. I understand, how Google may not actually recommend that process, but thank goodness Detective Qualley did that in this process and went to another Dakota County judge to get a warrant authorizing the identifying information from, in your hypothetical, Justice Thiessen, would have been 3 different
And they probably
devices.
would have given probable cause for all 3
I
for
don't
the
know,
same
but
reasons.
well, maybe and maybe not. I mean, it was one of those.
Well, I'm not saying, and that doesn't defeat your argument that an independent magistrate would have found probable cause. Yeah.
Right. I mean, I think that the point is that an independent magistrate would have been asked and would have had to weigh in about whether probable cause existed. And so I think it's incredibly fact dependent. And that's it's so important to understand here is we didn't have that, but to go to your example, if we had one of those, collection of data points directly above the culvert, but we had one of them, 30 feet down the road, and one of them a little bit further. Maybe in that incremental process that I think this court is embracing, you only get the identifying information for the one that was over the culvert, even though all 3 may have went to that gas station afterwards. And so you need to be targeted. In this particular case, there was only one device that obviously led to anything.
Counsel, step 2 of the warrant, as I understand it, gives officers a fair amount of discretion to determine which accounts are, quote, identified as relevant for further investigation. And that language seems to me to be pretty general and gives law enforcement a lot of room to work with. And I'm just wondering, where are the guardrails there? Kind of following up on Justice Hennessy and Justice Thiessen's question. I mean, for others, privacy rights there, that, people's private information could be revealed. I mean, how does law enforcement take that language and determine which accounts are identified as relevant?
I mean, step 2 does not have the warrant authorizing process immediately before it, unlike steps 1 and step 3. But step 2 is thoroughly discussed in the application for the initial geofence warrant, and it's even included that process in the warrant that Judge Lehman signed himself. So,
But counsel, there's no evidence in the record, is there, that the application was included with the warrant when it was served and processed?
My understanding is it was. They were included together when they were received into evidence as Exhibit 13 at the suppression hearing. There's language in the warrant itself that incorporates the affidavit.
But did
as well.
Google get the application with the warrant? Is there any evidence of that?
I don't believe so. And that partially is because of the stipulation that happened at the beginning of the evidentiary hearing. On page 4 of the May 17th, 2022 evidentiary hearing, this is appellant's trial counsel, not Ms. Workman, a different attorney, appellant's trial counsel referring to the exhibits showing the data received from Google, who would have been explaining what led to the production of those spreadsheets that are, again, exhibits 2 and 3. And appellant's trial counsel says, the parties have reviewed the exhibits that the state intends to offer. The state has the necessary foundational witnesses present, but the defense is agreeing to stipulate to foundation so that we can proceed to the substantive testimony. The defense essentially stipulated to the question you're asking me, Justice Hennessy, which is what information did Google get? My understanding is they received both of the warrant and the affidavit. If there's anything in the record that contradicts that, I apologize. But that is my understanding. Again, the record being limited because of that defense or appellant stipulation.
So with that stipulation, you're saying that's not before us, essentially?
It's been agreed to, yeah, which is also the reason that there's not, as compared to some of the other cases that are cited, like Chaudhry, for instance, they have voluminous testimony in that case at the district court level about how Google tracking works, where that information is gathered from, how it is stored, how is then accessed in response to warrants, and that was essentially stipulated away in this particular case. Justice Moore, I want to quickly return to your question. About the guardrails that are on there. I think those guardrails come in is that it's still anonymous at that stage. And that, in the warrant, the second warrant, Exhibit 14 from the suppression hearing, that is presented to get that identifying information, Detective Qualley described exactly what he found in response to the anonymous data requests, showing that there was one device, more so than any other device, substantially so, that had the 46 data points in that area and that moved outside of the tighter geofence area to the Speedway gas station afterwards, and then there was some connection between other information that the investigation had heard in that case in terms of the black Malibu Max vehicle and one of the other people, not appellant.
How about the point that your opponent makes, though, that in this particular set of facts, obviously we're dealing in a rural area and there was one clear number, I guess, or phone that was pinged. But should there be a different standard in urban areas? I mean, is that a concern that we should be considering about in terms of, the potential for effect on others?
In response to the urban versus rural argument, I think the Fourth Amendment requires that because the Fourth Amendment is incredibly fact-specific. Fourth Amendment analysis in whatever case, similar to this, different from this, involving geofence warrants, not involving geofence warrants, will turn on particular factual circumstances that differ from whether it is the side of a county trunk highway, to whether it's a residential street that I live on, to whether it's Interstate 94 cutting through the gut of St. Paul. It is very factually specific. And that is just the nature of the Fourth Amendment, including as well as the Minnesota constitutional provision that with identical language. And so, yes, it may be different depending on where this particular geofence warrant is drawn, but that's the point, and that is what the Fourth Amendment requires.
So picking up on that and moving a little bit to probable cause here. So what if we agree with you that there's probable cause to get a geofence warrant around the culvert? What is the limiting factor there? Because, it could have been a tighter area around the culvert. You also could have saw a warrant that covered the whole road that the culvert's on, and maybe there is. Where do you draw the line in terms of probable cause and the nexus of the area drawn and the crime committed?
Well, to be clear, our job at this point is just to determine whether there was a substantial basis for the issuing magistrate to have a fair probability the evidence of the crime would be found.
But our job is to figure out where those lines get drawn, and so how do we know that this area was a tight enough nexus, whereas, something for all of Dakota County probably wouldn't, right? And how do we draw that line?
Where's the line? A culvert, in this particular case, 21-inch tube directly below the road. I understand that the opening is to the side of the road, but even if you drew, it's a 65-foot by 290-foot space, this geofence warrant, even if you tighten that just more so around the opening to the culvert, to the tube itself, you're going to get part of the road because that's just where the culvert was on a very practical level. And then in terms of the reasonableness, you had information before this that's included in the affidavit to that first geofence warrant, that there were multiple people that were involved in killing the victim in this case, and multiple people that then were involved in transporting the body to wherever it was going to be transported to. Ultimately, over a month later after the murder is when it was finally recovered. And so with that multiple people piece, you could have had somebody driving in a car, riding in a car, who went to this area and didn't actually go to the exact mouth of the culvert, but was still involved in concealing that dead body, even if they weren't involved in the murder itself. And so having a little bit of a larger space to capture someone who may have left their phone in the car when they were putting the body in the culvert, or someone who stayed in the vehicle itself after riding or driving it there so they could act as a lookout, as people are pushing the body inside the culvert. That's very reasonable under these facts.
Can I ask
Of course.
one more question on the second step?
Yes.
So in the warrant, it specifically, it does, it gives guidance about, there's a question about giving discretion to the police to determine who's relevant. And I'm kind of moving beyond that. I think that's still a question. But then it says you can get, 60 minutes plus or minus to determine path of travel. And then it says the purpose of getting this information is to rule out certain people because they actually weren't in the geofence area. They actually weren't there. The police use it for a different purpose, which is to find out, they went to this gas station, and we get to look at the video. Does the purpose limitation in the warrant mean that the police didn't actually have authority to look at to use this information in a way that was different than what was actually allowed in the warrant?
I don't think so. And I understand how it looks, hindsight's 2020, in terms of the vehicle being seen by the surveillance cameras at the Speedway gas station. But let's change the facts a little bit. What happens if that vehicle, when it was found at the Speedway gas station, was a public works vehicle, or some sort of vehicle that's typically tasked with maintenance on roads or maintenance on culverts? And then that would have been a reason to rule out that particular device, from being involved in the murder, potentially.
Right, but that's just not what the language is. I don't think they could use it to do, it doesn't say that they can use it for that purpose either. It's basically, like, if the location puts them in a little bit different area, then kind of statistically it shows that they're not there. It says the reported points are not indicative of the device actually being within the scope of the warrant, which means, I guess
I see the trouble with that language. I believe that's stock language that Google developed with counsel at the Department of Justice when they were first coming up with guardrails to use for this geofence warrant process. And as an example of an abuse.
Well, why did they, I mean, maybe that is the guardrail, that they don't want them to do this stuff without an additional warrant.
I mean, let's look at the, look at the Smith case, the Fifth Circuit case from last month that found that geofence warrants across the board are categorically barred. In that particular case, first off, the law enforcement asked for a geofence area that was 57 times larger than what it was in this case. But on top of that, what they actually received from Google was 4 times that. So it was actually well over 200 times larger than this one. But the point is what they asked for and what they received from Google were actually different. That did not happen in this case. But going to your question of like what the purpose of step 2 is, it's maybe to correct an error like that where it accidentally uncovers, if the geofence warrant in this case was 1,500 feet
That's
too
what I'm
large
saying the
in
purpose
every
is.
direction. Right.
So, and this is not to say you couldn't get that second step, but maybe you should go back to the judge to get a next warrant to get that next step.
I can see, and again, in embracing that incremental approach to these law enforcement investigations, particularly something that has some sensitivity, I understand where the amici are coming from in that point. I could see that as a prospective rule, something that would be possible. I would urge this court not to require that in this case, because given when this search occurred, I think that the detective went above and beyond what Google was telling him to do, frankly, and was trying to be incremental and was drawing the line at the difference between anonymous and non-anonymous. I can understand where you're coming from, Justice Thiessen, about having that additional step.
The question is about whether this warrant was sufficiently particular, right? Not whether we thought that law enforcement did the right thing. It's whether the warrant was sufficiently particular. And the language of the warrant matters, not what law enforcement ultimately did. Isn't that right?
It is, and this warrant was sufficiently particular based on the unique facts in this case, based on the desolate stretch of road, the 31 days between when the victim was last seen and when his body was recovered, the fact that no one could date when he actually died because of the level of decomposition that the body had experienced by the time it was finally found by the farm worker. So, I mean, in terms of like the parameters of the original geofence warrant, I think they were adequately particular given the concerns. There was no building anywhere in this, third of a football field.
And I get that. My concern is the 1 hour on each side where those officers could have chosen anyone who came into that geofence for a 3-week period and pulled all of the data tracking those people with no tie whatsoever to any sort of nexus of probable cause.
If they had done that, and then they had sought a warrant like Detective Qualley did at that third step to try to get identifying information, seeing where this device went, again, a much smaller sliver of what happened in Carpenter, but I see what you're getting at, Justice Hennessy, then the magistrate should have denied that. I mean, frankly, that should not have been, or should have been suppressed later on if the magistrate who has presented that information at the step 3, had granted that in terms of, because, okay, week 1, we had, I believe, 12 devices. One of them turned out to be the devices associated with the appellant, and then there were 11 other devices that were in that, third of a football field 1 to 2 times passing on that road. If they had asked for probable cause, law enforcement had believed there was probable cause for the hour expansion at step 2 for those 11 other devices, that then it would have presented that in the updated affidavit that went along with the second search warrant. That search warrant should have been denied or it should have been suppressed if it was granted. That's my position.
It was a narrowing process, because wasn't there so there was the 11 that had 1 or 2, but the individualized one was 46 times, if I recall.
46 data points for the device that was ultimately associated with Mr.
Which is what that incremental
Appellant.
process.
Correct.
And under this warrant, they actually could
The
have.
first or second one?
At the first one.
Thank you.
So going to the second step of the first one.
Follow.
So they found the information. There's no geographic limitation at all, right? So they could have actually asked for stuff within, 60 miles.
Well, they couldn't have asked for something within 60 miles. They could have asked for something up to an hour. So there's a temporal restriction as opposed to a geographical.
Okay, 30 miles, I guess. I mean, it depends how fast you can go on that road.
Right. I mean, it could have been how fast do you drive, right? I mean, so 100 miles. I mean, it could have gone, right. It was on a plane.
Is that an issue?
Like that. Is it even further? So.
Is that an issue?
I don't think so, because you had both the temporal and geographic restriction at step 1. And you can't look at step 2 in isolation. You have to look at where it comes from.
No, I agree with that, but
So-
I'm just saying, all it says is you can look 60 minutes in both sides.
Right,
But
right.
they could look much, I mean, this would, when we're talking, well, it's just this culvert. Now we're talking about a huge area, right?
You are, but you're only talking about it for an hour. And say you had the data
Counsel,
points.
when you say that you're only talking about it for an hour, it just seems to me you are grossly minimizing people's privacy interest. I mean, I think most Minnesotans would be shocked to learn, and tell me why you think I'm wrong, would be shocked to learn that even if it's just within that hour span, that they can be tracked in that way without any warrant, any finding of probable cause. I
They
think
cannot
most
be
peop-
tracked that way. Their device anonymously can be tracked that way, and that's a really important point here. I understand the vehicle went to the speedway, and I understand there was surveillance video. But Chief Justice, I mean, if that went anywhere else, say a different direction, because the other side, went into a dirt road, an even more desolate area than where this culvert was. I mean, there would have been just, they went off the grid in that direction. So I think the anonymity at that stage is crucial. And I'm not sure where the 60 minutes came from. That was some sort of compromise. I can assume the record does not state this, so I'm extrapolating here.
Well,
But between the
get it.
DOJ
It's
and Google at
anonymous
some point.
I get that it's
Yeah.
anonymous at that stage, and if you can't be identified, you can't have a privacy interest. And I mean, I think that's your point. But, and maybe we've covered this ground, but we know that eventually the information identity can be discovered. And I think that's part of your opponent's concern, is that it doesn't stay that way for long.
It can if there remains probable cause. Like, if, for instance, in those 60-minute period, because I feel like the question is really focusing on that, the 60 minutes before or afterwards, it went somewhere else in which was not indicative at all of, being connected with this murder, unlike in these facts, then there would not have been probable cause to get the identifying information that's associated with that
But what
device.
is the indicative of all? Is it the fact that they got to the gas station and they could get the video, or is it indicative of, well, it's likely that because of the direction that they went, these people actually were at the culvert? I mean, I would think you would argue that that would allow the police to get probable cause, because the whole purpose of this expansion is to find out, was the identification in step one of being at the culvert accurate? And if it was, I'm sure you would be up here arguing it proved it was accurate, even if they didn't get any other information. But the thing that they could also get then is if this person, went to a known drug dealer's house later, or if this person went to a prostitute later, or if this person went to a church later and didn't want their
All the concerns of
religious things
Carpenter.
to be.
I understand where
Right,
you're
so I
coming
mean,
from.
I'm not sure that you can just, in some sense, the gas station kind of disrupts this whole analysis in a lot of ways, I think.
I think you're right about that. I feel that you, at the beginning of your question, put out like two different options and then assumed that I was going to select or think that there was probable cause for the second one. And I feel if we can go back in time, I really would have honed in more on the first one, because we have, yes, the device going to that gas station.
Well, that's
and
the easy one.
Right.
In
the direction of Minneapolis, which is where the murder happened, because there's information.
But that's not the purpose. The purpose is just to the whole purpose of the second step really is just to say, was finding the person at the culvert accurate? And I think you would argue, if we found someone who was at the culvert, and say that again, there were 2 10-minute periods, there's probable cause for that person to be a suspect here.
Related to your question, I feel, is like what facts, different from what we actually had in this case, would have undermined the anonymous information that was gathered at step one of showing these 46 data points right above the culvert. And I can't think of that right now, but I think that's what your question is kind of
Well, my
getting at.
question is, say there were 2 times on 2 different days where there were 46 data points over the culvert. And in neither case did they stop. I mean, there was not the gas station for either of them. They just drove away, and the subsequent information about where they drove, not going towards Minneapolis or anything, just showed that it was accurate that they were there, which is, I think, again, the point of the second step.
That's what the language is.
You're right. And so you would say, well, there's probable cause because they were there for an extended period of time. It strikes me that at that point you go to get a warrant, that's enough.
Yeah. Chief Justice, I see my time is about to expire. Can I try to respond?
Yes.
Thank you. Justice Thiessen, I would go back to the discussion that happened with Ms. Workman before about, in the state's position, these are not that dissimilar and actually quite similar to a surveillance video camera. So you say you have a surveillance video camera, and you have it, a deer stand or a trail camera, and you happen to have it on this desolate stretch of road aimed towards the culvert. And you see a car stop there for 10 minutes on one day, and then you see, 2 days later, another car stop there for 10 minutes. And it's grainy and it's far away, but you see those two vehicles. But somehow you're able to draw, I guess, the make and model from them and then do some investigation based on both of those. I think both of those would justify a continuation of investigation with respect to both those vehicles until you found out more that could rule out one of them.
And can I just one more follow-up?
course.
It kind of flows from that, but it's a little bit different question. So it seems like really at the end of the day, the big question in this case is how much we want new technologies to be used by police, right? And I think in Carpenter, they're basically saying that kind of new technology, we're not going to let police use it because it changes the relationship between government and individuals because it's so powerful. But for video cameras, we clearly allow, I don't think there's any question that if there's a video camera trained at this site, that there'd be probable cause. So this one's a little bit in the middle, and I know you want it to be more like the video camera. And I think that's one of the things I'm struggling with. Is it more like the video camera, or is it more like a tracking device that follows your movements as you kind of move around life? So can you just give your, briefly, your best argument on why this is more the video camera than the tracking, or not the tracking, the cell phone tower data?
When I read Carpenter, it goes in great detail talking about how encyclopedic and comprehensive all of the CSLI data in that case is over the complete week. And that's where the questions were coming from before about showing someone going inside a mosque or an abortion clinic or a gay bar or something else that you would want to have a reasonable expectation of privacy in your whereabouts. And that does not happen with geofence warrants. It would be an interesting thought experiment.
Except maybe the second step. But fair.
Right, an hour versus 7 days, which is what the issue was in Carpenter. And Carpenter itself, in the 5-4 majority opinion offered by Chief Justice Roberts, calls it a narrow decision. They explicitly did not address, even though they referenced it, the issue of cell tower dumps, which is actually where you're getting identifying information right out of the gate because you're dealing with a phone number as compared to, a unique bland identifier like you had in this case. So if in Carpenter you had, a much smaller window of time, an hour, and a space that was not everywhere over the course of a week, because you can drive basically everywhere in a week. But just again, starting with a rural spot in Castle Rock Township, I think the outcome in Carpenter could have been quite different.
Thank you, counsel. Ms. Workman, you've got 5 minutes for rebuttal.
Thank you, Your Honor. Your Honor, I want to address counsel's argument about that stipulation, what the stipulation actually was to. It was to the specific data points, the Excel spreadsheets. It was not to how Google's processes work, and that is not at all in our record. Your Honors, I also want to talk about the issue of whether Step 2 is too expansive because it can track you beyond the boundaries of the geofence warrant. I would say to you that it is too expansive at that point. We keep talking about a video camera trained upon the boundaries here. This is no longer a snapshot of what is happening when you go beyond the boundaries. Now you have an ankle monitor, and that is exactly what Carpenter found was wrong.
Do you think it would have been different, though? Do you think it would have been different if they would have gone back before taking the second step to get another warrant?
I'm going to tell you that what I believe happened here and why it happened the way it did. This was the first time that Detective Qualley had ever done a geofence warrant. He was really following the directions from Google. Google's policy is that you can do 60 minutes before and 60 minutes after. And I think he did not think that through, whether he needed a second warrant. And then when he got to the third step and got the second warrant, it was because Google had said to him, there are some cases coming out from federal districts, you probably want to go get a second warrant.
So I'm just saying, had he thought ahead and actually returned to get a second warrant, that would be a different case than this case, before the second step.
It might be, but I have to tell you, I have such problems with step one.
I'm assuming step one's okay.
Was any of what you were just saying to us, though, in the record? I mean, are you drawing that from testimony or from something in the record, or are you just speculating what you think the detective was thinking about in the process?
That's what I've learned from the amici of how the Google process works and what I believe.
But is it in the record?
It's not in the record, Your Honor.
And then if in fact this was his first time and he was just following Google in good faith, what does that do for the good faith exception?
Well, there should be no good faith exception, and that's because Minnesota has a very strong history of
But
not.
doesn't this seem like maybe a case because it's
This
so
is,
new?
there's one case where we have a good faith exception, that's linguist. This is not a linguist.
And
This
the
is
good
not.
faith exception is like if there's no law on something and the officer's
Right.
acting, just for everybody out there, acting reasonably, we kind of give a pass the first time.
That's right, but so in the federal districts, for everyone's edification here, the federal districts, they allow the good faith exception pretty broadly. Minnesota does not have that, and we have heightened protections here for a reason. And when you look at our recent case law, Malika, from March of this year, this court declined to apply the good faith exception yet again and talked about the Minnesota tradition of having expansive protections. So if this court finds that under the federal constitution, this warrant was okay, I urge you to find that it was not okay under the Minnesota Constitution. Our legislature has conferred reasonable expectation of privacy upon our cell phone data under 626A42, and our Constitution says, I apologize, going beyond our time, our Constitution gives us greater rights.
You still have a minute and a half.
Yeah, we're on the clock.
If I could jump in? Or-
Yes, Justice Procaccini.
So just on Carpenter, I'm still struggling with exactly how Carpenter applies here. Because in Carpenter, it was about a lot of information about one person over time. Here, it's, at least at step one, let's just stay focused on step one, it's a little bit of information about a lot of people for a even longer period, at least under the warrant, right? And so how do you balance a lot of information about one person who we know and identify versus a little bit of information about a lot of people?
They're equally bad, I would say, and equally scary. Because in that case, yeah, you may be following, in Carpenter, you're following one person. Here, you're following 31 people, and their rights are caught up in this, as well as my client's rights. And because of the pinpoint precision, because of the accuracy, even though it may be just a snapshot of your life, that is still a very revealing snapshot. What if you had gone to a brothel? What if you'd gone to an abortion clinic? What if you'd gone somewhere to have an extramarital affair? That is the type of thing that should be protected by the Minnesota Constitution and the federal Constitution. Thank you, Your Honors.
Thank you very much to both attorneys for the help that you provided the court today. And thank you in particular for joining us in our traveling oral argument. We know that requires you to do a few extra things to get here, and we're so appreciative that you were willing to do that. The court, we're now adjourned, and the court is going to break. We're going to go backstage, take our robes off, and then come back out for question and answer. I would say to the attorneys, you are more than welcome to stay yourselves. Usually people leave, the attorneys leave, but you are more than welcome to stay. And we'll do Q&A with our students here for the next half hour. So thank you all. Thank the both of you for coming, and we are adjourned, and court will be back out shortly.
Everyone can stand up and go ahead. Before we go on with that part, I want to take a few moments and thank everyone who made today possible. First, I'd like to thank Principal Mark Winter. Where is he? There. Thank you. I'd also like to thank Rockridge High School staff and the staff from School District 2909. Thank you so much for accommodating us and hosting us today. And I really want to take a moment to also acknowledge the student guides that we have here today. The high school has provided the justices as well as myself with student guides who are meeting with us, taking us where we need to be. It's been a real pleasure to meet them, and it's a testament to the school of how hard they've worked to make today smooth. So thank you. Let's give them a big round of applause. I also want to take a moment to thank several district court judges who are here with us today. Judge Michelle Anderson and Judge Andy Peterson are both here. They're accompanied by law clerks also from our district, Dave Arndt and Abby White. They're both here. Both are Virginia grads, I believe, so also available to answer questions later in the day if you have them. I also want to take a moment to thank some attorneys who are here with us today, who came into your classrooms and talked with you about the case and the court system. Mark Muich and Bruce Williams, both from the 6th District Public Defender's Office. Give them a big round of applause. Nothing that the courts do ever is without the help of law enforcement and security. And so I want to thank the Virginia Police Chief, Nicole Mattson, for coordinating officers from local police departments, Virginia, Evelyn, and Gilbert, as well as the Minnesota State Patrol, who are providing our security today. Thank you for your commitment and hard work to keeping this a fun and safe event. Again, I also want to thank Rockridge School District for providing a live broadcast for our communities and surrounding schools so that they could participate in today's events without actually having to be here. And then thank you to all of you. Thank you for being so attentive. Thank you for the questions that I know that you've prepared to talk with the justices about. It's exciting to me to come into high schools and just see how engaged our students are and inquisitive. So thank you. Okay, yeah, go ahead. So, the fun part about today is about to begin. Pretty quickly here, the justices are going to return to the stage to answer your questions. I believe we have some microphones and that are over here, or they're right here. They're here in the middle of the aisle, so we're going to ask you to line up behind those microphones with your questions. I just want to make a reminder to everyone, you've probably already been told this, but none of the justices can discuss today's case that they've heard or any case that is presently in the courts. If they were to talk about it, their comments could be construed to not be neutral, and the appellant or the respondent in this case or any other case could think that they weren't being treated fairly, so it's really important not to ask specific questions about the case. But there are a lot of questions that you can ask about their background, their experience with the court, or anything else that's outside of that. So I'm not sure if they are here. Are they back from the robing room? Are you back? You're back. All right. So without further ado, the Minnesota Supreme Court.
Well, thank you, thank you. You guys have been a great audience already, so thank you so much for your participation and your attentiveness. I also want to extend my thank you again to your principal, Mr. Winter, and all of the staff here at the school, and likewise to the many law enforcement offices that help make this happen. I know we've got law enforcement from Evelyn, Virginia, and Gilbert, and the State Patrol, and certainly the folks here in Virginia obviously had to go out of their way in particular to make this a reality. So thank you to law enforcement for being here. What we're going to do now is just a Q&A, and before we get into that, each of the justices will introduce themselves, tell you a little bit about themselves, and then we'll open it up to questions. My name again is Natalie Hudson, and I'm the Chief Justice of the Minnesota Supreme Court. I'm a 1982 graduate of the University of Minnesota Law School. Most of my practice as an attorney was in the public sector, including 8 years, almost 9 years at the Attorney General's office doing appellate work, exactly what you saw the attorneys here today doing. And so I did that for about 10 years before I was appointed to the Court of Appeals, which is our intermediate appellate court. And I was on the Court of Appeals for 13 years, and I've been on the Supreme Court for the last almost 10 years, and the last year as chief. So thank you, and I'll turn it to Justice McKay. While she's doing that, let me remind people, we do everything here in order of seniority, and so you'll notice that that's how it goes, and that's why I'm going to Justice McKay first.
All right, I think maybe, yeah.
Now it's working. Holy smokes. My name's Ann McKeag. I'm from Federal Dam, Minnesota. How many of you know where Federal Dam is? Okay, there are a few. Okay, well, it's the adults. Leech Lake. Everybody know where Leech Lake is? Yeah, there we go. Okay, so my hometown's 106 people. It is a little bit west of here, so it's great to be up in the northern part of the state. I've been on the court since 2016. I'm the first Native American female in all of the United States to be on a Supreme Court, so it's pretty cool that we have that in Minnesota. I went to Reamer High School, for those of you who know where Reamer is. I think I had 60-some people in my class when I graduated, and now there's like 5 that graduate, so it's gone down a little bit. And then I went down to St. Catherine University in St. Paul to college, and then on to Hamlin Law School, and then I was a county attorney for 16 years doing child protection work. I also had a specialty in cases that fell under the provisions of the Indian Child Welfare Act, and I also did some adoption work. And then I was on the district court, so I was a trial court judge for almost 9 years in Hennepin County, and then I ended up on the court here. So thanks for paying attention. Oh, forgot about that.
Hi, I'm Paul Thiessen, and I have been on the court for 6 years. I grew up in Bloomington, and as a lawyer, I worked for some law firms in Minneapolis having businesses fight with each other, and some healthcare law, so helping nursing homes and assisted care facilities and that kind of thing navigate their way. I also served in the legislature for 16 years, including 2 years as Speaker of the House, and then was appointed to the court by Governor Dayton. And my wife and I have, is that me? Oh, okay. I thought a podcast was starting. Have three kids who are kind of in their early 20s.
Well, hi, everybody. My name is Gordon Moore. I grew up in Rochester, Minnesota, where the Mayo Clinic is, if you've heard of that. I spent college years in Northfield at Carleton College, went to the University of Iowa for law school, and then started at the Attorney General's office in St. Paul doing litigation, but spent 26 years in a little town called Worthington, Minnesota on the Southwest Prairie, close to Iowa and South Dakota, where I was a private practice attorney, city attorney, county attorney, and then a district court judge for 8.5 years before Governor Walz appointed me to this court in 2020. And I can just say that this high school has got to be the envy of any school in the state of Minnesota. You should be so proud of what your communities have done for you. We go to a lot of places, and this is really top notch. So thank you for having us.
Hi, everybody. I'm Carl Procaccini, and I'm one of the newer justices on the court. I've been on the court for a year and a day. Yesterday was our anniversary. And so my legal career included private practice, where I was a partner at a law firm. I also was a government lawyer. I was the governor's general counsel for a number of years. And throughout my career, I've taught at Minnesota law schools. And so immediately before I started on the court, I was a law professor at the University of St. Thomas School of Law. Really always excited to visit high schools because my first job when I graduated from college was teaching at a high school and teaching band in particular. And as it turned out, I wasn't the best band director, but learning that set me on the path to studying law and going to law school and entering this career, which I absolutely love. So great to be here with all of you.
Hello, I'm Sarah Hennessy. I'm one of the newest justices on the court. I've been on the court since May, so I'm still learning the ropes, trying to figure out how this all works. I graduated from a small private college in Iowa. I grew up in Iowa. Don't hold that against me. Went to law school at Drake, and then practiced as an appellate defender for a couple of years in Iowa, so doing what you saw the folks do here today. Then I moved to Spain, which is a story for another time, and then I moved back to the US, and I moved to DC. And while I was in Washington, DC, I worked as a criminal defense lawyer at the trial level, and I did that for quite a while, both in the public defender's office and then later at a law firm. And then I moved to Minnesota in, 2005 or 2006, and I've been here ever since. Since I moved back to Minnesota, I worked at Legal Aid. So when I was working at Legal Aid in St. Cloud, which is where I live now, I worked primarily representing women who had been victims of domestic abuse and helped them in whatever help they needed in the court system. So doing orders for protection or divorce, custody, a whole host of civil matters that they found themselves needing help in. So I did that until I was appointed to the district court bench, which is where the trials happen. And I did that in Mille Lacs County for 5 years, and then I did it for another 7 years in St. Cloud, where I live, until I took the bench with the Supreme Court. And my children are around the ages of the people who are here in the audience. I've got a child who just started college and a child who is a sophomore in high school. And so it's really special for me to be here talking to all of you about the work that I do. So thank you for having us.
Hi, everybody. My name is Teddy Gaitas. I'm the mystery justice who did not sit on the case today, but I'm happy to be able to join my colleagues on stage to talk to all of you a little bit. I am the most junior judge on the court. I've been on the court for 2 months and 2 days, if we're being extremely precise. I went to the University of Minnesota for law school and spent most of my career as a lawyer, as a public defender. And for most of my time as a public defender, I was an appellate public defender. And in fact, I did a whole bunch of these kind of arguments at high schools myself when I worked in that position. And so I really feel for the attorneys. I know the appellate public defender who appeared before you today has already hit the road, but the attorney who represented the state is still here. And, lawyers, they train to give arguments in front of other people, but not like this, not in front of a huge audience of high school students. And so I really sincerely thank both of them for being here today, traveling from the Twin Cities to be here today and for presenting their argument so that you could see what it's like in a courtroom. I was also a judge on a couple different levels of our court system. I was a district court judge, which is where the trials happen, which was where the case you heard today started. And I was also a judge on the Court of Appeals before I was appointed to the Supreme Court. And I'm the last person to give my introduction now, so I think that we will next transition into some Q&A. Thank you.
Thank you, Justice Gaitas. So it is time for a Q&A. We've got a mic there and a mic stand there. And so let's have some questions. This is an opportunity for you guys to ask the court any questions you might have. Don't be, oh, good. There we go. I was going to say, do not be shy. Wow, one person stood up and then everybody stood up. Okay.
They're ready. Okay, why don't we start right here with you, young man? Shh, quiet, 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 quiet. Oh, well, we're gonna start with you, young man. There you go, it's on.
What do you see as one of the biggest challenges facing the Minnesota judiciary in the coming years, and how can the court address these challenges?
I would just say the complexities of what's been going on in the world. I would say the amount of work. A lot of the trial court judges, they don't get a lunch break. They don't have time to use the bathroom. It is just a vicious cycle of trying to deliver justice, but on a really fast pace. And I don't think we can continue to require that of them because it's just too much. And so it's really trying to, I think, better give our justice partners and ourselves the ability to do this work more thoughtfully.
Thank you.
Hi, my name's Talon, and I have a question about the George Floyd trial, Derek Chauvin. Due to the new information of George Floyd's medical condition and the body camera footage that came out, I'm wondering if you're going to take another look at the trial.
We can't really comment on that because it could come to us. So I'm sorry about that.
Hi, I'm Cody Hadid, and I first wanted to thank you guys for coming all the way out here for us. But I also had a question about how your job being a justice affects your personal life and like the pros and negatives of being a justice.
That can be my answer.
Really good question. The district court judges have a little different connection with the community than the state Supreme Court, but there's obviously a public face to the Supreme Court, and we're all part of that. And when we make decisions, they get in the news sometimes, and it's unfortunately you don't have to look very far to find out examples of people that are in the judiciary being subject to some sort of public criticism, even violence, sadly, if you're aware of what happened in Kentucky recently. It's a factor that is out there. Personally, I try not to let that define who I am or how I do my job, but I think, I worry more about my family. I've got 3 children, wife, old cat. I mean, other people get affected by me and my role, and that actually is something that I do think about. But fortunately, our Minnesota community is pretty supportive of the judiciary, and we really appreciate that.
Thank you.
My name is Will Kemp. My question is for Justice Gaitis. Why do you think Governor Walz chose you over other people in your field?
Well, I can't really speak to Governor Walz's thinking processes, but perhaps Governor Walz was interested in having someone on the court with a lot of appellate experience, which is certainly something that I gained during my career as an appellate public defender and as an appellate judge on the Court of Appeals. Hopefully he thought I was kind of funny too. That's always a pitch that I make. It's important to have people who, have a good sense of humor, especially when working with, a group to make group decisions as we do. Thanks for the question.
Hi, my name is Hallie Pauling, and once again, thank you for being here. And I have a question for Justice Thiessen. You said you worked in the legislative branch, and now you work in the judicial branch. Which one do you prefer and why?
Well, I very much prefer this job now. I loved working in the legislature, and the difference, one big difference, kind of in response to someone else's question too, the thing I love about this job is I actually get to think about stuff. and take my time in making decisions. In the legislature or being a lawyer or lots of other jobs, you're always kind of reacting to stuff, which is exciting, but it's also like exhausting. So this is exhausting maybe in a different way, but I love, and I feel very grateful to be able to do this job. The other thing I loved about the legislature, though, was that, well, two things. One, you kind of get to go out and reach for issues that you want to make a difference on. As a judge, you have to wait for them to come to you. And the second thing is, in the legislature, I got to do a lot more stuff like this, go out and talk to people and meet with people. And being a judge can be a little bit more isolating, if that makes sense. So they were both great, but they're kind of different in those ways. And the other thing I would say, the other great thing about being a judge is because these cases are all kind of stories, you know, talking to my wife and kids about kind of the stuff that's coming before me, they get what I do now much more than they got what I did when I was in the legislature.
Thank you.
Hello, I'm Ethan, and my question is, before becoming a justice, do you work any jobs during high school or college that you feel prepared you and gave you any skills that you use in your day-to-day life?
Yeah, I had a number of jobs in high school. I worked at a movie theater where I popped popcorn, and but in terms of jobs that helped me prepare for this job, I spent an entire summer, one summer in my hometown, guarding a parking lot. And all I did was read that whole summer, and I read philosophy, and I read all sorts of things. And in this job, that's much of what we do, is we read, and we read critically, and we analyze the briefs that the parties are presenting to us, but also the case law that they're citing, and all the information that comes before us. And so one of the key components of this job, and a lot of legal jobs, is being able to read and read carefully and critically, and that's just super important in this job. But I would say all my jobs over the years prepared me. Even being a high school teacher and teaching law, you sort of learn that back and forth Socratic method, which serves us well as we sit on the bench like you just heard today.
Thank you.
Hi, I'm just wondering, this is kind of a broad question for anyone. How much influence do you believe the public opinion should have within the court of law or the justice system?
Well, you know, I'll answer. Yeah, okay. No. You know, two answers to that. Obviously, we're human beings. We read the newspaper, we watch TV, we listen to the news, we do all of that, and to some extent, you want us to do that. You want us to be well-read and understanding and appreciating what's going on in the community and the world around us. By the same token, though, one of the foundational principles for us as judges is we're bound by the rule of law. We're bound by precedent. We're bound by what we call stare decisis, which is just the rule or the principle that we follow the cases that have come before us for consistency. And it depends on the case that comes before you and what the facts of those cases are. And so our first requirement as justice, and particularly on the highest court of the state, is to apply the law as best we understand it to the facts that are before us, regardless of maybe what's swirling around us in terms of public opinion. That's not our role as justices, to be guided by that. What you want from your judges and your justices is an impartial and neutral fact finder. We are not legislators. I mean, you need to appreciate the different roles of government and separation of powers. As a legislator, that is a very important role where you do care about public opinion. In fact, you seek it out and to determine what the policy is you want to advocate for. We have a very different role as judges, and so it's one that we take seriously and respect seriously.
Thank you.
Hi, my name is Ingrid. I actually have two questions, if that's all right.
Okay.
So my first question is, if one of the purposes of the law is to provide stability in society, how wrong do prior court decisions have to be to justify being overturned?
Justice Hennessy, you wanted to tackle that?
Boy, I feel like I'm interviewing with the governor again. So you're asking if there are prior decisions that this court has made, how wrong do they have to be for us to overturn them? Is that essentially your question?
Yep.
Well, we have case law that says there has to be a compelling reason to overturn precedent. And I won't bore you with the test, but there's a 4-step test, essentially, that we have to apply to decide if a prior decision should be overruled or not. So the good news for everyone is that we can't just sort of randomly decide, hey, we don't like what the Supreme Court did 10 years ago. We're a different court now. We'd like to change that because we feel differently. We can't do that. We take our precedent very seriously. And so we have guardrails that guide us in deciding whether it's appropriate given changes in society, given what other cases say, what other courts are doing, what the U.S. Supreme Court obviously is doing, that help us determine whether there is any validity to revisiting an old case. Does that answer your question?
Yep. My second question is, if evidence of a crime is suppressed when a police officer doesn't follow the law correctly for doing that, doesn't that also mean that some crimes go unpunished and deny justice to victims?
Teddy, I think it's your turn.
The short answer is yes. That happens all the time. But the rationale for that, of course, is to protect the rights of all of us. The remedy of suppressing evidence, do you guys know what that means? If evidence is wrongfully obtained, the defendant can seek to have the evidence thrown out simply because the way it was obtained violated the defendant's constitutional rights. That's very extreme. And yet the purpose of that rule is to deter misconduct, to make sure that law enforcement is being very careful in how evidence is obtained. And occasionally, law enforcement is being very careful, and it still turns out that there was some kind of a problem that implicated the constitutional rights of the defendant. And yes, on occasion, that does mean that a victim isn't served with justice, but that is something that our courts, it's a time-told remedy, our courts have determined is important enough, is significant enough to protect the very fundamental rights that we all have to privacy under the federal and state constitutions.
Thank you.
Thank you. We've only got a few minutes left, so maybe we can do like a rapid fire one. So one question and we'll try to answer it. We've got about 5 minutes left.
My name is Ethan Bergerson, and I was wondering what you guys' favorite pastimes are.
Singing.
Do you want to hear her sing?
Sure.
He really has a nice voice. I know.
Thank you.
All right.
Hello. Have there been times when you've made a decision that you did not agree with, but you felt like you needed to make that decision because of the rule of law?
Absolutely, yes. I would say a not insignificant number of times that would be the case. Coming back to the earlier question, there's lots of times where I would say, if I was in the legislature, I would have done it this way, but the legislator decided to do something else, so we have to do that. That happens all the time.
Thank you. I'm River Galloway, and my question was just a general one. Do your morals or personal philosophies ever get in the way of your jobs? And if you had a hard case that challenged your beliefs, how do you handle that?
That's a really good question. I think your obligation as a judge is to set aside your personal beliefs, your moral beliefs, but there's that part of you that's always there. And so some of these cases, kind of like the last question, I say the heart and the head may not be in perfect alignment. If, the law says one thing, your gut tells you something else, that can make it hard to be a judge, but we have an obligation to follow the law.
Hi, my name is Jace Matuzak. Thank you again for you guys coming down. I'm sure you're getting sick of hearing it. But, so my question is, I mean, we've seen, like, this court, we have people from very rural Minnesota and people from, like, the metropolitan big city. So what do you think are some of, like, the pros and if there are any cons of having a court with people from the big city and rural Minnesota?
Yeah, I mean, hard for me to identify the cons because we're hearing cases from around the state and we have statewide jurisdiction. So I think the more viewpoints we have on our court, whether it's rural or urban or different practice backgrounds, we all bring to bear, the life experience that we have, where we grew up, how we practiced, and all of that is for the better. It would be a bad thing if we were all from the Iron Range, or we were all from the cities, but the fact that we have that diversity on our court makes us stronger.
Thank you.
Hi, I'm Georgia Duffy, and again, thank you guys for coming down. It's super awesome to just see you guys and hear from you. I wish I had time to ask all of you guys the same question, but I guess I'll go directly to Chief Justice Hudson. I guess my question is, what motivates you in your everyday life? What kind of keeps you going and keeps you in and help motivate you?
Oh, that's a great question. It ties into really with something Justice Thiessen said. I love the practice of law. I love being a judge, being a justice. The ability to take a difficult legal issue, work through that, understanding that, especially here on the Supreme Court, that what we're doing is writing a rule of law for the entire state of Minnesota. How you balance the equities in a particular matter, what that rule of law should look like, that motivates me. That's a fascinating process. And just being able to dig into a complex area of law and try to figure out, it's like putting a puzzle together. It's a legal puzzle. How is this all going to fit together? And what's the right answer? What's the fair answer? What's the answer that best fits the people of the state of Minnesota? It's a tremendous responsibility, but it's also something that is very fulfilling to do. And so that's what motivates me. One last question, and then I think we have to call it quits.
And I'm wondering, what is your favorite part about being a judge?
Justice Gaius, you want to?
Justice Thiessen mentioned the stories and how it's easier for him to explain to his family because what we're dealing with are stories, and I think that's my favorite part of being a judge are the stories and the people behind the stories. I just think it is fascinating to hear about people's challenges, people's triumphs, and sort of everything in between. And so that's my favorite part about being a judge is getting to learn those stories and more about the people behind them.
Well, thank you. That is all we have time for. Yes, thank you. Round of applause. Thank you all. It's been a pleasure to be here with you. I'm going to turn it over to Principal Winter.
Thank you, everybody. Students, awesome job. Thank you so much for coming. Again, thank you for the Supreme Court. What an honor. Students, I know many of you have left your backpacks, your books, everything in second hour. We are nearing the end of fourth hour. So middle section, I want you to stay sitting for a minute. The two sides, you may exit, and we will soon be in fifth hour.
I think we should go. Yeah.
Middle section, hang loose for a minute.
Oh, you want us? Okay, all right. He wants. No, that's fine. He wanted us to hang on for a second. You may want to. No. Yeah. Okay.